Dear friends, this video deals on Constitution 130th Amendment 2025, which is being introduced by the Home Minister Amit Shah in Lok Sabha. Without any discussions or debates on the matter, even without circulation among the members of Lok Sabha, even without the knowledge of the NDA allies partners, the bill was duly introduced by Amit Shah, the Home Minister, without any discussion and debate, and without asking for any parliamentary standing committee reference of the bill. He himself has referred the matter to the Parliamentary Affairs Standing Committee for scrutiny. This is nothing but mockery of parliamentary democracy and proceedings and conventions that has been established in the Indian Constitution. The point here is that what does the bill say? A Prime Minister or Chief Minister under custody for 30 days in a case punishable with 5 years or more will cease to be Prime Minister or Chief Minister on the 31st day of his custody if he doesn't resign before that. Likewise, such a minister will be dismissed by the President or the Governor, as the case may be, on the advice of the Prime Minister or Chief Minister. If there is no advice, he will cease to be a minister on the 31st day. This is going against the established criminal jurisprudence that is existing in India. The liberty and freedom of an individual is the cardinal principle of Indian democracy, and the due process of law is there. An accused person shall be treated as only an innocent person until proven guilty is the cornerstone of Indian jurisprudence, but without any trial or conviction by the judiciary, the executive itself has taken the powers of the judiciary. It intruded into the judicial independence and the basic doctrine of the Indian Constitution. What is irony is that this thing has been very serious of nature, has been introduced by the Home Minister without any discussions in the Parliament, so as to divert the attention of the people of this country on Bihar voters theft and many other irregularities that have been committed by the Election Commission of India in Maharashtra and Karnataka, and in Assam also. In many parts of the country, the voters list is either increased or decreased so as to suit the BJP and allies parties. The point here is that this bill needs to be passed only by 2/3 majority of both the houses of Parliament in Lok Sabha and Rajya Sabha. The point here is that in Lok Sabha, the ruling NDA has 293 MPs out of 543 members. It needs 332 votes to pass. And in the Rajya Sabha, out of 245, NDA has just 133. India Alliance 78, whereas the 2/3 majority to pass the bill in Rajya Sabha works out to 164. In both the houses of the Parliament, in Lok Sabha and Rajya Sabha, it is crystal clear that the ruling NDA Alliance is not having 2/3 majority so as to pass the bill. Knowing pretty well that this bill will not be ratified even by the Lok Sabha or Rajya Sabha, having no two-third majority. Why it is introducing is that it is diverting attention from the people, because the Supreme Court of India Constitutional Bench is hearing the presidential reference of 14 questions on the powers and functions of governors and the president on the timeline to pass the bills passed by the legislative assembly. Hence, the Supreme Court of India is going to give the verdict as enjoyed by the two members Supreme Court judgment on Tamil Nadu versus Union of India on April 8. It will not nullify the definitely the judgment made by the two members judgment on April 8th of this year. Definitely the reference made by the President will be given fitting answer by the Supreme Court of India. Under this backdrop, the government of India is introducing this bill so as to nullify the constitution, so as to undermine the judiciary. It is against the basic principles of the constitution. The basic structure of the Indian constitution is that democracy, federalism, republic, rule of law, individual liberty, judicial review, and the powers of the people vested with the people's sovereignty, that is people's democracy, that is parliamentary democracy, shall not be altered even by the laws made by the parliament. Hence, in order to nullify the basic doctrine of basic structure of the constitution, it is made laws. This is against the constitution.